The Eighth Circuit issues a catastrophic ruling. That's according to Democracy Docket. We know Democracy Docket, organized by Mark Elias, a lawyer responsible for a lot of the 2020 election litigation. A lot of it we covered here on this channel. This is from their website. They wrote the word catastrophic. That's not mine. They say, oh no, the Eighth Circuit rules that private plaintiffs, so people who are private citizens filing lawsuits, cannot sue under Section 2 of the Voting Rights Act. And this is the section of the act that Mark Elias and Democracy Docket and many of these lawfare lawyers were using to exploit the rules. And so here is what they say from Democracy Docket, right? This is them saying, we're not happy about this. They say, in a catastrophic 2-to-1 ruling, the Eighth Circuit Court of Appeals held that private litigants can no longer bring lawsuits under the Voting Rights Act. In practice, this means that in the Eighth Circuit, only the U.S. Attorney General and not private groups, which is what Mark Elias and many of these people were doing. They were funding these things, right? They were creating these little cabals of people who would go and file claims. And we saw this back during COVID. It would be like the Retired Alliance Association of America. Like they'd form some organization and they'd get people in it who had standing because they were located in the state, and they would sue the secretaries of the state, like in Pennsylvania. And they would say, COVID's here. We have to change all the rules. Waive this and waive that and allow signatures and big ballot requirements and blah, blah, right? It was madness. We covered like a dozen lawsuits here. But they were being sued. So this private group would sue the secretary, and then the other party would respond. So they would sue to try to change it. Then Trump would have to respond and then get this multi-party lawsuit effort going. And then what would happen is the judges would just agree with the Secretary of State and just make the rule change. We said, that's strange because the state legislature says you can't do that. And so now the court says, out of the Eighth Circuit at least, that those private groups, those retired associations, blah, 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 all of these organizations cannot bring a claim anymore under key provisions of the Voting Rights Act. They say in legal terms, the ability of private groups and individuals to bring lawsuits is referred to as a private right of action. Now, this decision, they say, is going to harm minority voters in Arkansas and 6 other states that are in the Eighth Circuit. They say the decision to dismiss this case, written by a Trump-appointed judge, harms black voters in Arkansas, and we want a fair state house map, right? So they usually will pick some group that is being victimized, and they'll use that group as the allegedly being victimized, and then use that group as justification to change the rules without going through the proper process. But here they say, now under today's ruling, the Eighth Circuit includes Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota, and they're saying they're very unhappy about it. So let's go and take a look at the opinion. It is relatively short in the context of these types of things. Before we read the opinion, here is what the New York Times says about it, right? They say the federal court moves to drastically weaken the Voting Rights Act. Almost certain to be appealed to the Supreme Court. It could effectively bar private citizens from being involved in these things. And currently, this is absolutely being exploited by the left. We've covered many lawsuits. In fact, you could even say that the Colorado ballot removal lawsuit is a version of this, right? It is a private plaintiff, a group of people suing the secretary in Colorado to remove Trump. Trump moves to intervene. It's the same format. And so they're saying that if you're going to bring a federal claim under the Voting Rights Act, or any claim under the Voting Rights Act, that is precluded in those states. So the ruling was made by the U.S. Court of Appeals for the Eighth Circuit. The opinion is very likely to be appealed. The 1965 Voting Rights Act was one of the most significant achievements, they say, of the civil rights movement. And the Court of Appeals said that the Voting Rights Act did not explicitly contain language for a private right of action. And so here was what the opinion looks like ultimately. You can see this is on appeal from the district court from the Eastern District of Arkansas. It's before 3 judges, Smith, Grunder, and Strauss. And here is the question that they are asking and then subsequently answering, saying, did Congress give private plaintiffs, guys like Mark Elias and the groups that they found, the ability to sue under Section 2 of the Voting Rights Act? Text and structure reveal the answer is no. Sorry. So we affirm the district court's decision to dismiss. Now they say, quarreling over district lines about where we draw the districts in various states, this begins like clockwork every 10 years after the United States census. After we know how many people are in the state, we have to redraw the lines because there's more people that came or more people that left. And so it's always a battle. In 2021, writes the court, Arkansas experienced it firsthand when it created 11 majority black districts out of 100 for electing members of its House of Representatives. Now, the Arkansas NAACP and the Arkansas Public Policy Panel, 2 advocacy groups with members living throughout the state, opposed the new map. Now, they sued nearly everyone that had anything to do with the new map. They said this is vote dilution, which comes in 2 forms. One is packing, which involves drawing lines that concentrate cohesive political group into a limited number of districts. districts. In this example, it's turning 3 possible majority-minority districts into 2 by bunching the group members into 2 supermajority districts. So you just draw the map to include all the majority people. You give them 2 ultra-majorities and you keep the rest. The other is cracking, is basically the opposite. It's just you divide them, you take one subgroup and you divide them amongst the other districts, and that way they're the minority share in every district. You either bundle them up and set them aside. So in other words, you give them 2 districts with massive majorities, but you take the other 3, or you take all 5 and you just spread them out across the 5, but they're a smaller majority, and you just draw the maps to match that. Here, they say Arkansas has allegedly done a combination of both, making it harder for black voters to elect the representatives they prefer. Now, allegedly, this new map denies their supermajorities or their right to vote because it creates supermajorities. Now, the advocacy group uses statistics to back up their claims. They say 16% of Arkansas is black, but the expectation is that only 11% of their candidates will win. The disparity, they say, is because you've got some hyper-concentrated districts through packing, and then you crack them. And they say this is not done intentionally, but they say that there are discriminatory effects. So they say, we've got 16% of the population here. We should expect to have 16% of the vote. Based on what we've got now, it's only 11. There is a discriminatory effect based on the new map, and therefore, this is unconstitutional. Now, early in the case, the district court started questioning whether the advocacy group had any cause of action under this law at all. Do you even have standing to bring this case? Like, do you have a private right of action to come and sue? So the question needed answering, and that's why we're here today. Now, after reviewing the text and the history and the structure, the court concluded that private parties cannot enforce this section. Only the Attorney General can enforce that, and he declined to do it. So we're appealing now, and we have some history. They say Congress passed the Voting Rights Act in 1965, and they did it to address entrenched racial discrimination in voting. There were provisions that all states had to follow, regardless of their history. One, Section 2. It stopped states from enacting any standard practice that denies or abridges the right to vote based on race or color. Now, early on, it had little independent force, but then in the 1980s, it came across increased scrutiny. At the beginning of the decade, the Supreme Court confirmed what many had already thought, what purposeful exclusion of voters was, and they said that discriminatory effects was not enough. Like, if it has some discriminatory effect, that's not our problem, right? It has to have a purpose. So that did not sit well, okay? So the court said, look, this is what the law says in this case. And Congress said, well, we don't like that interpretation, as is their right. And so Congress can pass new regulation in order to rectify what they think is a misinterpretation of the law, right? The court is just interpreting it. Congress can say, well, that's a pretty bad interpretation. That's not how we meant it, so we're going to fix it. They did. Now, in lieu of this, they adopted a discriminatory effects test. Now we're asking ourselves, does it meet the test? And when they changed it, they modified this, but when they made the changes, they didn't change anything about who can sue. Okay, so the test is different, but not about the standing, about who can actually gets to sue. But that's the centerpiece of this case today. The question is, who can sue? And it says the list only names one plaintiff who can enforce it, called the Attorney General. Now, we need to decide if naming one person, the AG, excludes the others. Now, when to imply a cause of action is bigger than just this case. The practice has been long controversial, in part because having a judiciary decide who can sue bypasses the legislative process. And they say when gaps exist, we might need to fill them in. Now, it's unclear, the court says, whether Section 2 creates an individual right under the law. Other statutes have different interpretations, but there are different elements in this one statute. And he does some textual analysis to really break this down. He says, everyone agrees that Section 2 itself contains no private enforcement mechanism. All it does is standardize and specify the procedure. But we must look elsewhere to who can do the suing. Section 12, rather, empowers the Attorney General, and the omission was no accident. One reason is federal observers have jurisdiction to monitor elections, and observers have the duty to notify the AG. And jurisdictions without federal observers are different. But they say the advocacy groups are urging us to look elsewhere. They want us to be able to allow this claim and allow them to sue. And they're doing some very kind of dense textual analysis here on what the words mean, like literally. Taking their cue from the word, quote, any, they're looking to Webster's Third New International Dictionary. But to accept this interpretation, we have to think that that word means this, and they want that word to mean that. And so as further evidence that Congress did not hide an elephant in this mouse hole, there's this little possibility that we could insert something here, but Congress probably didn't intend to do that. The group's argument would make a mess of other statutes. If we did what you say and interpreted it this way, it would throw the whole library out of array, because that interpretation we'd have to carry over to this case, and this case, and this case. If private plaintiffs have the same causes of action as the Attorney General, then the reverse is true too. And it would go both ways. And obviously, that doesn't make any sense. So interpreting it the way that we do, on the other hand, avoids the apparent inconsistency that you guys are proposing. Private plaintiffs can sue under a Section 1983 claim when it's appropriate, when there's a violation of their rights, and the Attorney General can do the same under the Voting Rights Act, under Section 12, and Section 3 sets out the ground rules for this. He says, look, we got to zoom out a bit on this. If we do, it becomes clear why these arguments do not work. The advocacy groups ask us to accept the idea that Congress decided to transform the enforcement of one of the most substantial statutes in history by the subtlest of implications. It's implausible, to say the least, when measured against the explicit enforcement mechanisms found elsewhere. Like, the statute is very explicit, so why wouldn't they be explicit here? Now, their argument goes to legislative history, but not text or structure. When you talk about legal analysis, there's multiple layers to this. Like, one layer of legal analysis is obvious. Just read what the text says and try to interpret the text. That's it. If it says the right to keep and bear arms, right, shall not be infringed, if it says that, just read it. That's it, right? You don't need to go much further into that. But other people will say, well, but what did that mean back at the time in the 1700s when they wrote it? And what does arms mean? And so let's go back into the history and say, what does arms mean at the time? And what does bear mean at the time? And further than that, right, that's another layer. Well, what does the word mean at the time? But there's another layer saying, well, what did they debate before they wrote those words, right? That's legislative history. When they were sitting around Congress writing the Second Amendment, what did they write? What were they debating? What did they redline? What did they include? What did they not include? Because that provides context, and that's legislative history. But there's some things that are more valuable, like what if the text says something that is opposite to the legislative history? What takes precedent? Well, obviously the text, right? Because that's what entered, like that's what got ratified by Congress and entered into law. So what they're saying is these other guys were looking at the history, but not the text or the structure. The statute is silent on the existence of a private right of action, but the committee reports are not. In 1982, when Congress amended Section 2, the committee wrote that they clearly intended, the committee, to allow a private enforcement. But there are many reasons to doubt legislative history, right? It's just legislative history. It's just debate, and it doesn't answer the questions in a satisfactory manner. Precedent provides little more than guidance, but like legislative history, has no firm answer. And so we have to look to decide whether this action exists. We talk about some Supreme Court precedent, and they are dismissing some other arguments, rejecting some of the advocacy groups' opinions. And here is how they conclude. They say, we reject the notion that we must unwind everything the district court did. After all, it's hardly unusual for us to hear and decide an appeal following a dismissal on the court's own motion. Now, particularly in a situation like this, after an opportunity for a full briefing and hearing. Now, the final loose ends that we need to dispose of here are regarding the advocacy groups adding a Section 1983 claim. Now, they say that we can enforce Section 2 as a component of 1983, but they never requested leave to amend, and complicating this matter is not something we're going to do now. So accordingly, we affirm the judgment of the district court, but modify the dismissal to be with prejudice. So you cannot file again. And we have a dissent here that you're, of course, free to read, but this is what the document looks like. It is a big ruling. Of course, Mark Elias and the Democracy Docket people not happy about this at all. The case is now dismissed, and it sounds like they will be appealing this. They said at Democracy Docket that when Republicans control the redistricting process, they're going to be discriminatory, and that they're going to continue to fight the Republicans who are stopping at nothing to weaken voting rights across America. So pretty interesting opinion. Now, of course, this will go to the Supreme Court, no doubt about it. At some point, we might have a district split where one other district says you can bring a private cause of action, but another district like this one says you can't, and maybe the Supreme Court will settle it. The question will be, will the damage be done prior to 2024 and those elections? Because these lawsuits are taking place right now. We're seeing them in various states to keep Trump off the ballots and to engage in lawfare. And if the Supreme Court doesn't settle this soon, those lawsuits in other circuits that are not the 8th Circuit will be allowed to continue forward. And so we'll be here continuing to cover, my friends. Thank you for joining us as we do. Thank you for subscribing and checking out robertgovea.com, and we'll look forward to seeing you on the next one.